Welcome to another short video from the Liverpool Law School tracking the process of the UK's departure from the EU. There's a lot going on at the moment, there always is, but this time our topic is one that you might not have heard so much in the news, yet it is a crucially important issue. It's just that with everything else going on, it just hasn't received anywhere near the attention and the scrutiny that it surely deserves. So, around the same time that the government decided that the UK will leave the EU single, internal, common market, whatever you want to call it, the government also started to talk about the importance of protecting the UK's own single or internal market, the market between England, Scotland, Wales and Northern Ireland. Now, it's always exciting when a new concept is born. What does it mean, this UK single market? By what principles will it operate? By what standards should we judge its success or its failure? And the key message of this short video is that there is a lot more to any internal market than the current UK debate would suggest. Internal markets are not merely about trade, they're also about fundamental policy choices concerning how to structure your economy and your society, and basic constitutional questions about your institutions, your processes, your values that underpin your public and democratic realm. And so the choices that are being made right now about the UK internal market will have a profound influence upon the future character of the UK and relations between its constituent authorities. Yet so far, the signs are not very promising. Now let's explain and explore those propositions in a little more detail. First, by recalling some basic ideas about any internal market, and then secondly, by offering more specific comments about the current UK situation. Now, any internal market between two or more territories, each of which is capable of enacting its own laws and regulations, needs to address two main issues. The first is how to define and address barriers to trade between the constituent territories, and in particular, as our previous viewers will already know, how far will the idea of a barrier to trade between the territories cover what is undoubtedly the main problem in cross-border commerce? The existence of simple variations between how different territories regulate goods or services, so that goods lawfully sold or services lawfully provided in territory X can't be lawfully sold or provided in territory Y without having to comply all over again with the different regulatory standards that territory Y applies to its goods and services. Different product standards, different qualifications, different supervisory bodies and so on. Now, those barriers to trade may not be protectionist, they may not be discriminatory, but they undoubtedly compartmentalise any aspirant internal market along territorial lines. So how far do we want to tackle them? The second main issue is how to define and address so-called distortions of competition, because different regulatory standards not only create barriers to trade, they also impose different compliance costs upon economic operators. More safety checks in one territory mean greater costs and higher prices than in territories with lower standards. Now, some people see these variable compliance costs as an artificial distortion of merit-based competition between private undertakings, and it needs to be eliminated. Other people, however, believe that variable compliance costs encourage undertakings to select the best jurisdiction to meet their regulatory needs, and that in turn creates a valuable competition between legislators, between territories, to meet the real needs of the market. But of course, for many other people, that's simply a polite way of saying that private undertakings can engage in social dumping. They can pick the territory that has the most permissive standards, which will then force other countries into a deregulatory cycle. And the question is, for all internal markets, which of those views should we hold? So we have two main issues that any internal market needs to address: barriers to trade, distortions of competition, and in turn we then have two quite highly stylised models for how to go about addressing them. Now, the first is mutual recognition. Now, taken to its logical extreme, mutual recognition means that any good which is lawfully sold or any service which is lawfully provided in one territory should be allowed to be freely sold or provided in all of the other territories of the internal market, without having to comply with additional rules or regulations within the host country. Now, that obviously solves the problem of barriers to trade, and it does it in a relatively straightforward way. But it leaves intact distortions of competition, it actively encourages regulatory competition between the territories, and it does place significant limits upon the ability of any given country effectively to enforce its own social policy choices. So for example, I might well decide that I'm going to restrict genetically modified organisms or highly polluting cars or gambling by undertakings which are established in my territory, but a strong duty of mutual recognition would mean that I can't stop GMOs or high polluting cars or gambling services coming in from the rest of my internal market. Now the second technique is harmonisation, and again taken to its logical extreme, harmonisation means that you have a central regulatory body that adopts a single regulatory standard that all of the territories have to comply with. Now obviously again that solves the problems of barriers to trade. There are no more differences between local laws. But it does eliminate any distortions of competition or indeed any scope for regulatory competition between the territories, and of course it's very difficult to reconcile with the very idea of regional autonomy or local policy preferences. Now those are highly stylized models, and in reality no internal market is going to be based simply on one or other of those two extremes. Instead we have to find the answers to two more real-world questions. And the first is, how will this principle of mutual recognition, how will the practice of harmonisation be combined together, be suitably adapted and be appropriately qualified so as to find a workable system that can reconcile the competing interests at stake, respecting each territory's regulatory autonomy, promoting cross-border trade within the internal market, safeguarding important social policy choices. And secondly, it's not just about finding this balance in the abstract, it's also about creating the institutions, the structures, the processes that will operationalise the entire system in practice. Who will be your common decision-making body? Who will be your independent enforcers? Who will be your impartial umpires in the case of dispute? Though of course the converse is also equally true. The type of internal market that you might dream of or aspire to can be influenced or restrained by the institutions that you simply have to work with in the real world. The key point is that every internal market is the product of its own unique circumstances and conditions. And that's true of internal markets which exist within a single sovereign federal state, such as the United States of America or Canada or Australia. And it's equally true of an internal market which is created between sovereign states through international treaties in a regional project of economic integration. The EU, of course, being the main example, but we can see more embryonic forms in South America or Southeast Asia. Every internal market is defined by how all of these variables interact. The substantive choices about autonomy, trade and social policy, the potential and the limits created by institutions and processes. And of course the relative weight of those variables will differ from sector to sector, and they will change and evolve over time. Internal markets aren't end states, they're not final destinations, they are processes that have to be directed and managed. And the UK experience will be no different. So what do we know then about the UK's plans for our single market after we leave the EU? And here we'll highlight just 4 key points for reflection for discussion. The first is, it's not clear how far the UK government is aware of the underlying issues which should inform these discussions and debates, or at least the UK government is hardly communicating and debating these issues to or with the public in a transparent manner. Instead, we seem to be making things up as we go along in the middle of a wider crisis of state policy with very little evidence of clear reflection or discussion about the nature of the choices to be made and their potential consequences. And in that regard, it really is worth noting in particular the government's treatment of the devolved authorities throughout this entire process of deciding what our internal market should be and how it might impact upon the constitutional structure of the UK. After all, Scotland and Wales have complained consistently and quite legitimately about effectively being sidelined and ignored by London when it comes to many of the key decisions about UK withdrawal from the EU, even as regards their impact upon the existing devolution settlements. And the treatment of Northern Ireland, whose interests are so closely tied up with quite specific and legitimate concerns about the border with the Republic, is effectively being held hostage to the partisan demands of the DUP, whose stranglehold over the minority Conservative government in London offers its hard-right MPs a disproportionate degree of influence, not only over the future of Northern Ireland, but actually over the future of the whole of the UK, a point made abundantly clear in the joint report agreed between the EU and the UK in December 2017. After all, one of the promises that the government made back then is that businesses in Northern Ireland should have unfettered access to the market in the rest of the UK, even if businesses in England, Scotland or Wales don't enjoy the same economic opportunities back in Northern Ireland. A rather lopsided version of the principle of mutual recognition, if ever there was one. The second key point, what can we learn about the substantive policy choices which might underpin the UK internal market, at least from the available documentation? Now, the UK government claims that its guiding principle is going to be that there should be no new barriers to living or doing business within the Union after withdrawal from the EU. Now, taken at its face value, that principle can only be fully realised or delivered in two main ways. Either through a very strong rule of mutual recognition, which means local autonomy, but also varying compliance costs, regulatory competition, difficult enforcement of social policy choices between the UK regions. Or alternatively, it might mean a very thorough and far-reaching programme of centralised harmonisation, which would mean very extensive intrusions into the regional autonomy and local policy preferences of Scotland, Wales and Northern Ireland. But we shouldn't assume that the government has such a well thought out plan either way. After all, there's no sign that the government is preparing or proposing some sort of underpinning charter that would actually define the basic principles, the frameworks that will govern the UK's internal market in a systematic or coherent manner. Instead, the main focus of the government's energy so far has been on identifying which existing fields of EU harmonisation should be preserved or replicated at the UK level, versus which sectors could be handed back to the devolved authorities after withdrawal. And as we know, those choices are the subject of strong and unresolved tensions with both Scotland and Wales, both of whom have accused London of using the UK's withdrawal from the EU and the empty rhetoric of protecting the UK single market as an excuse for a naked power grab and centralisation. Now, even without any need to take sides in that ongoing constitutional tussle, what we can certainly say is that there's only a limited value in drawing up a list of fields where common frameworks already exist at the EU level and should now be retained by London for the sake of protecting the UK internal market. Because after all, such a list presupposes that we've already made clear and considered choices about a whole range of prior questions. What is our internal market seeking to achieve? How do we define barriers to trade? How far do we want to tackle them? How do we define distortions of competition and how far do we see them as problematic? What balance do we want to strike between harmonisation and mutual recognition in any given field? And what degree or nature of harmonisation do we think it's necessary to pursue in any given sector? And what are the obstacles to cross-border trade that we're prepared to tolerate and for the sake of which fundamental social interests? Without thinking and answering those really basic questions, how do we know that the UK list is the right one? Instead, it feels like these very important judgments are being made based on little more than a selective trawl through the EU's own unique experience of what it is to create the EU's own unique internal market. Third key point. Nor is there much evidence of a critical reflection about the institutional arrangements that will or should underpin the functioning of the UK's internal market so that it operates in a clear and controlled but also a territorially balanced and democratically representative manner. If anything, the UK government seems content to graft the policy choices which it's inheriting from the EU simply onto the pre-existing institutional framework of the UK constitutional order, with its highly particular method of balancing power between the centre and the devolves, let alone between legislature, judiciary and executive. Let's just recall a few very basic points here. By its very nature, the UK is of course a deeply asymmetrical quasi-federation in which England is by far the dominant player. And that dominance is reflected in the fact that the central legislative power is overwhelmingly comprised of English MPs, and indeed England as a territory has no legislative representation which is distinct from that of the central parliament itself. The protections afforded to the devolved authorities are essentially process-based and political in nature rather than substantive and legal in character, especially after the Supreme Court judgment in Miller. And there are a few other constitutional devices that protect the interests of the devolved authorities. For example, there's no domestic equivalent of a principle of subsidiarity that would create a constitutional presumption in favour of regional power and require central harmonisation to be positively justified. So where are the clear rules of the game? Where are the even-handed institutions? Where are the independent umpires that might operationalise the UK internal market in a fair and transparent manner? Fourth and final key point, of course, all of these questions about the nature of the UK internal market can't be answered in isolation. They're closely tied up with the UK's external policy choices and future international relations. Now, the UK government does recognise this, albeit in a limited manner, insofar as it seeks to justify the choice of fields where common UK frameworks may be required, not only so as to avoid creating new barriers to trade within the UK single market, but also where they're considered necessary to enable the UK to strike free trade deals with third countries. As we saw in Liam Fox's speech on the 27th of February 2018, this power to negotiate large numbers of groundbreaking trade agreements all across the world is one of Brexit's most cherished pipe dreams. But one of the many costs of Liam Fox's fantasy trade policy may well be an ill-thought through and ill-defined set of restrictions on the regulatory competences of Scotland, Wales and Northern Ireland. Because once again, the relationship between an internal market and its external trade relations is far from obvious or self-executing. Different choices can be made about just how far the state's pursuit of an external trade policy should impact upon the structures and instruments of its own internal market. For example, how far can binding commitments externally be reconciled with the internal choices that the state has made about mutual recognition or harmonisation? Or how can regional governments and legislatures represent or defend their local policy preferences during the formulation of external trade policy by the central government? Again, where is our open and rigorous debate about these very important choices which are currently being made by the government? And of course, in the UK context, much will also depend upon fundamental decisions that remain to be made about future relations with the EU and how these will impact back at home upon the policies and institutions of the UK domestic markets. For example, if the UK does eventually remain closely aligned to the rules of the customs union and the single market, EU law might well continue to provide the framework that will organise trade within the UK as well as with the EU. And if it's not the EU, maybe it will be the Americans or the Chinese or the WTO that will end up shaping or even making these types of decisions for us, whichever, in fact, of the major global economic powers that ends up taking back our control. Let's conclude. Will the UK's newfound single market be the product of rational and informed choices made on the basis of clear and considered options, decided through inclusive and transparent democratic debate? It appears not. Instead, the UK internal market seems to be evolving through ad hoc discussions and decisions, undertaken simply as part of a wider crisis management strategy and conducted largely behind closed doors with minimal public or stakeholder scrutiny. And so far, at least, one suspects that if the UK's rather chaotic and opaque approach to building an internal market proves sustainable at all, it'll probably be more by accident than design. So, I hope that's been a useful diversion from the daily torture of the UK-EU withdrawal negotiations, but we'll be back soon from Liverpool with more comment and analysis on the latest developments under Article 50.